The following is a presentation on the new Glendale Rental Rights Program, which establishes new rights and responsibilities between landlords and tenants in Glendale. On February 12th, the Glendale City Council adopted Ordinance number 5922, also known as the Rental Rights Program. The program was established to provide stability and to mitigate the impact of displacement caused by high rent increases in Glendale. The Rental Rights Program is comprised of three components: updates to the existing Just Cause Eviction program, the additions of a Right to Lease program, and a Relocation Assistance program. The City of Glendale first established the Just Cause Eviction program in 2002. Just Cause Eviction addresses the 12 legal reasons for eviction and other issues relating to the termination of tenancy. The following are exempt from the Just Cause Eviction program: parcels containing 2 or fewer dwelling units, accessory dwelling units, single-family houses, condos and townhouses, rooms or accommodations which are rented for a period of less than 30 days, Section 8 housing and/or other government-subsidized units, and other limited circumstances. Under Just Cause Eviction, tenants are eligible for relocation assistance in certain circumstances. This is not to be confused with the new Rental Rights Relocation Assistance. Under Just Cause, tenants may seek relocation if being evicted for the following reasons: permanently removed from the rental housing market or requires eviction for demolition. Unit requires eviction for major rehabilitation. Landlord evicts for the occupancy of family. When landlord evicts to comply with the governmental agency's order to vacate. Due to condominium conversion or for commercial use of the property. The relocation calculation for a just cause eviction is 2 times the current fair market rent, or FMR, for a rental unit of a given size plus $1,000. For example, if a tenant living in a 1-bedroom unit is evicted under certain conditions, the landlord must pay relocation equal to 2 times the FMR. The FMR for a 1-bedroom unit is $1,384, an amount established by the United States Department of Housing and Urban Development on an annual basis. In our example, the landlord owes the tenant $3,768 in relocation assistance. In February 2019, the Just Cause Eviction Ordinance was updated. The update removed the provision that allowed owners to be exempt from the ordinance by offering a 1-year lease. The update added a new provision requiring enhanced documentation for capital improvement and demolition projects. One of the new sections of the Rental Rights Program is the Right to Lease. With Right to Lease, a landlord must offer a lease with a minimum term of 1 year to all prospective tenants, as well as current tenants whose rents the landlord wishes to increase. A tenant can accept or reject the 1-year lease. If a tenant rejects a 1-year lease offer, the tenant and landlord can enter into or continue with a month-to-month or other type of lease. If the rent increase is over 7% within a 12-month period, and the tenant rejects the lease, the tenant may ask for relocation if eligible. We'll discuss eligibility in upcoming slides. The first time a right to lease is offered under the new ordinance, which took effect on March 14, 2019, the tenant has 14 days of being served to accept the lease or request relocation if eligible, or else the offer is deemed rejected. Once a 1-year lease is in place, the landlord must offer to renew the lease for another year, 90 days prior to the expiration of the existing lease, at which point the tenant has 60 days to accept or seek relocation for increases above 7%. If the initial 1-year lease is rejected and the tenant is on a month-to-month agreement, the landlord must offer a lease with a minimum term of 1 year to the same tenant upon the notice of the first rent increase after the first year anniversary of the rejection. Failure to offer a right to lease renewal shall render future rent increases null and void. The following are exempt from right to lease: rental units located on a parcel containing 4 or fewer dwelling units, accessory dwelling units, single-family houses, condos and townhouses, rooms or accommodations which are rented for a period of less than 30 days, Section 8 housing and/or other government-subsidized units, and other limited circumstances. Another new component of the rental rights program is relocation assistance. A tenant is eligible for relocation assistance when a tenant elects to vacate a unit in response to a rent increase of more than 7% of the rent that was in place at any time during the 12-month period preceding the effective date of the rent increase. A tenant must request relocation in writing within 14 days of service of rent increase notice. The following are exempt from relocation: units constructed after February 1, 1995, rental units located on a parcel containing 2 or fewer dwelling units, accessory dwelling units, single-family houses, condos and townhouses, rooms or accommodations which are rented for a period of less than 30 days, Section 8 housing and/or other government-subsidized units, and other limited circumstances. Relocation assistance has 3 parts. Depending on their situation, a tenant may be eligible for different relocation calculations. For parcels containing 3 or 4 units built before 1995, a rent increase over 7% within a 12-month period results in a relocation assistance calculation equal to 3 times the current rent. For example, if the current rent is $1,000 and the landlord raises the rent by 10% to $1,100, the tenant is eligible for $3,000 in relocation assistance. With parcels containing 5 or more units, the tenant's household income is taken into account. Tenants with a household income above 130% of Area Median Income, or AMI, receive a different relocation benefit than tenants whose household income is below 130% of AMI. AMI is established by the United States Department of Housing and Urban Development on an annual basis. For parcels containing 5 or more units built before 1995, a rent increase over 7% within a 12-month period, coupled with a tenant household income above 130% AMI, results in a relocation assistance calculation equal to 3 times the proposed rent. Proposed rent refers to the new rent being requested by the landlord. For example, if the current rent is $1,000 and the landlord raises it by 10% to $1,100, the tenant is eligible for 3 times the proposed rent of $1,100 for a total of $3,300 in relocation assistance. Now let's take that example with one difference. This time the tenant's household income is below 130% AMI. In this case, the relocation assistance calculation also factors in the number of years occupied. Number of years occupied refers to the amount of time a tenant has resided in the unit. For tenants who have resided in the unit from 0 up to 3 years, the calculation is 3 times proposed rent. For tenants who have resided in the unit from 3 to 4 years, the calculation is 4 times proposed rent. For tenants who have resided in the unit from 4 to 5 years, the calculation is 5 times proposed rent. And for tenants who have resided in the unit for 5 or more years, the calculation is 6 times proposed rent. As an example, let's say the current rent is $1,000. The landlord raises the rent by 10% to $1,100, and the tenant has been in the unit for over 4 years, but less than 5 years. If the tenant chooses to move and asks for relocation assistance, the new ordinance determines that the number of years occupied is 5 years, meaning the relocation assistance calculation is 5 times the proposed rent of $1,100, equal to $5,500 in relocation assistance. Now let's talk about banking. Banking is part of the relocation assistance component of the rental rights program, and it allows landlords to save any unused rent increases and apply it to future rent increases. Landlords may bank no more than 21% worth of rent increases, and they may use no more than 15% of banked rent increases at any time within a 12-month period without triggering relocation. For example, if a landlord does not increase the rents for 12 months, they have banked 7%. The next year, if the landlord chooses, they can increase the rent for a total of 14% without triggering relocation. The rental rights program also requires that a notice of rent increase include language advising tenants of their relocation and lease offer rights. The landlord cannot impose a rent increase if they fail to notify tenants of these rights. The rental rights program took effect March 14, 2019. The rent rollback established by the program took effect April 1st. On April 1st, rents for all applicable units reverted to rent in effect on September 18th, plus any legal increase up to 5%. Any rent increases following the rent rollback must provide notice of relocation and lease offer rights to applicable units. If a landlord issued an increase on March 1, 2019, to take effect April 1, 2019, and met the requirements of the ordinance by offering a 1-year lease and/or notice of relocation rights, the issued increase can take effect April 1st. If the landlord issued an increase to take effect on April 1, 2019, without meeting the requirements of the ordinance, rent will roll back effective April 1st. This concludes the presentation briefly highlighting Glendale's new rental rights program. For more information, future updates, and useful resources, please visit glendaleca.gov. You can also email rent@glendaleca.gov or call 818-548-3926.